Page 78. Meaning of Juristic Act and Contract. Juristic Act. Juristic Act means any voluntary and lawful act, the immediate purpose of which is to establish between persons juristic relations, to create, modify, transfer, preserve, or extinguish rights. Normally, the general principle of laws prescribes every person has his or her freedom to enter into contract, freedom of contract, meaning that he or she can conclude any juristic act and contract in any manner to the extent that it shall not be contrary to law and public order and good morals. Contract. Contract means the juristic act as agreed to be made by both persons or more, whereby a party makes an offer and the other party makes an acceptance. The contract shall occur only when the offer is identical to the acceptance. As a result of the fact that contract is a form of juristic acts, contract is under the frame of juristic acts, that is, freedom of contract manner, to the extent that it shall not be contrary to laws and public order and good morals. In this respect, there are certain categories of contracts which are often used in daily life, such as purchase and sale, pledge, mortgage, borrowing, and suretyship. Moreover, to prevent confusion, the laws prescribe that the forms of contracts which are often executed in daily life in a specific manner are called specific contracts. Categories of contracts. Sale. Sale contract is the most frequently used contract in daily life. It is a contract which the seller agrees to transfer the ownership in the properties to the purchaser, and the purchaser agrees to make the payment to the seller. In the sales contract, certain criteria which should be known are prescribed by laws as follows. Purchase and sale of immovable properties, for example, house, land, or special movable properties such as floating house and beasts of burden, shall be made in writing and registered by the competent official, or else the contract shall become null and void. Purchase and sale of the movable properties in the amount of 20,000 baht or more shall have the sales evidence or shall have a deposit. Otherwise, in the case of dispute, the party is unable to file legal proceedings with the court. Hire of property means a contract as agreed by the letter to let the hirer to use the property for a certain period, and the hirer agrees to pay a rent therefor. The hire is the contract which the letter trusts in the hire on an individual basis. Therefore, the letter is unable to sublet the property to another person. If not, the letter can terminate the contract of hire. In principle, the hire is in accordance with the freedom of contract. That is, there are not certain criteria of hire, except for hire of immovable properties, as prescribed by laws, that if the parties do not execute the contract of hire, in the case of dispute arising, they shall not file legal proceedings with the court, and if the hire of immovable property has a period of time exceeding 3 years, it shall be made in writing and registered by competent official, and each term of hire shall not exceed 30 years. Borrowing means a contract the lender allows the borrower to borrow money, provided that the borrower promises to repay the loan, and, according to the law, the borrowing may be completed without interest payment. Hence, the borrowing may be made without interest so charged. But if the lender desires to charge the interest with the borrower, the lender can do so at the rate not exceeding 15% per annum, and the borrowing in the amount of 2,000 baht or more shall have borrowing evidence, or else the party cannot file legal proceedings with the court. Mostly, when there is a borrowing, the lender is likely to think that only the interest rate of 15% per annum may not be worthwhile, due to the fact that the borrower may not perform his part of the contract. Thus, the lender is likely to opt to enter into another contract stipulating the instances of pledge, mortgage, and suretyship. Pledge means a contract that the pledger delivers a movable property to the pledgee as a security for performance of obligation, and when the pledger fails to perform the obligation, the pledgee can sell such property by auction. Mortgage means a contract whereby the mortgagor assigns a property to the mortgagee as security for the performance of obligation without delivery of the property to the mortgagee. The mortgage shall apply to the immovable properties and special immovable properties and other immovable properties as particularly registered. The mortgage shall be made in writing and registered by the competent official, or else the mortgage shall become null and void. Suretyship means the contract whereby a third party called the surety binds himself or herself to a creditor to satisfy an obligation in the event that the debtor fails to perform it. The obligation of the surety shall arise only when the debtor fails to perform the obligation. To the extent that the debtor continues satisfying the obligation of the surety would not yet occur. A contract of suretyship is not enforceable by action unless there is some written evidence signed by the surety. In this regard, when the surety has already performed the obligation in lieu of the debtor, the surety can claim his or her own amount as paid to the creditor from the debtor. Vocabulary: Juristic Act, Hire Purchase, Interest, Contract, Pawn, Pledge, Suretyship, Contract of Sale, Mortgage, Surety, Lease, Loan.